Now, as Catherine mentioned, Stanley's acquittal brings a basic legal process into sharp focus again, how juries are selected and how issues of race play into the right to a fair trial. And that is the focus of our question tonight. Does Canada have a jury problem? Successive justice studies in this country going back decades certainly think so. The family of Colten Boushie certainly thinks so. A jury that appears all white, chosen so quickly, seemed to send chills.
It was really difficult to sit there today and watch every single visible Indigenous person be challenged by the defense.
If Canada's system feels discriminatory, do the numbers bear that out? Jessica Orkin practices Aboriginal, constitutional, and criminal law. She says there's an abundance of anecdotal evidence and an absence of facts.
We don't, in Canada, collect information on the racial identity or any identity of jurors. So the only evidence that exists is anecdotal, of people like in the Boushie family saying that people who were visually identified as Indigenous had been the subject of peremptory challenges.
And there's that controversial phrase, peremptory challenges, the ability to dismiss a potential juror without giving a reason.
Which, allow for that split-second decision based on intuition, based on based on bias in some cases, of just saying, this is not someone who I want to have on the jury.
Ottawa could eliminate peremptory challenges altogether with a criminal code amendment. It's been suggested a few times over the decades. Other countries have done it. In 1986, the U.S. Supreme Court declared it unconstitutional to eliminate a potential juror because of race. A good idea, but lawyers have just become more sneaky, devising questions that supposedly prove a potential juror can't be impartial. No mention of race. A 2004 Texas list of acceptable reasons, for example, to eliminate potential jurors included agreed with the O.J. Simpson verdict or watched gospel TV programs. The United Kingdom abolished challenges without cause altogether in 1988. Canada's reaction after watching the changes in those two countries? Just give both defense and the prosecution the same number of peremptory challenges. They now each get 12. And what adds to the complications in Canada is that every province has its own system for deciding who's on a jury pool in the first place. In Saskatchewan, it's based on health card data. In Alberta, it's about the driver's license. In places, it's been about the voters' rolls. So there have long been systemic biases at work well before anyone even gets to the courthouse.